Good evening, everyone, to
Good
Home
evening.
Buyers Made Easy. I know we usually do it on Thursdays, but we have an amazing guest tonight, and I'll kick it off to Buffy to get to get everything going. Go ahead, Buffy. You have the floor.
All right, all right. So our job, in most instances, you're coming to us to purchase the home, the building, whatever the asset is. What we're wanting to talk about tonight is how to safeguard your asset. And so we have Miss Laurore JeanPierre with JP Law. And I wanted to read her bio. I have known Laurore for a couple of years now, and she has been a great asset, a great educator in this field. And I just thought it would be best to bring on somebody that is versed in this industry so that she can share information with everyone. And like she said, now that you bought the asset, now what? So Laurore JeanPierre is both a licensed financial advisor and a Florida licensed attorney. With over a decade of experience in financial industry, she has built a substantial network and book of business from top-tier institutions such as Wells Fargo, Charles Schwab, and Merrill Lynch. Early in her career, Laurore identified a significant gap in proper financial planning and legal access for lower income groups. This realization motivated her to pursue a legal career. While unconventional, Laurore worked full-time in the financial field while attending law school. Graduated with honors, cum laude, from FAMU College of Law. Okay, I know everybody that went to FAMU will have something, to say
Go
about
ahead,
this.
Rattlers.
Laurore is deeply passionate about finance and believes in the freedom that comes with financial control. She exemplified this belief by graduating from law school without incurring any debt, thanks to her meticulous financial planning. Currently, Laurore serves as the managing attorney at her firm. Her mission is to help clients build wealth through market investments and safeguard that wealth by establishing trust. All right, Laurore, I'm going to hand the floor over to you. So I know that you probably get this question a lot, and I remember us talking about it on your podcast. One of the biggest things that people think or what realtors want our buyers to know is to file their homestead if it's their primary residence, right? But you share with me that there's so many other benefits to filing homestead, and I wanted to hit on that point first.
Yeah, definitely. A lot of times we think about homestead, we don't think about the tax savings. We don't think about the other things. And one of the major things, especially for new homeowners, is knowing that your home is protected from lawsuit, right? So meaning that if that is your primary residence and you have filed homestead for it, let's say you get into a car accident, that's the question we get a lot. Oh my gosh, they're going to take my home. They cannot. If that is your primary residence and you have filed homestead for it, that property is protected. They cannot force you to sell that property to satisfy a debt. And I think we talked about the four exceptions, right? HOA at the top because they're their own government. Unfortunately, HOA, and I think you said this, Buffy, can foreclose on you faster than the mortgage can. That's an exception with that. Then
Yes,
you have a mechanic lien. Yes, it sure can. Then we have a mechanic lien, meaning someone has worked on the roof or they fixed something in your home and you haven't paid. That's something that even if it's your homestead property, they can still have a claim against. And then of course we have the mortgage, right? The mortgage is just how it is. Like if you have, they're just gonna take it back. And then of course the government. So those are the four things that if you have homestead exemption, that someone cannot force you to sell your property just to satisfy a debt. So it's just beyond just getting that tax exemption. It is Florida law, Florida Constitution, that if that is your homestead, the goal behind it, the intent behind it was to try to protect your home, to make sure that your home is your safe haven, right? A creditor from a car accident or business transaction shouldn't be able to force you out of your home. So a lot of times, we think about the homeowners, it's like, oh yeah, I'll get to it to get my tax exemption. No, you want to get to it as soon as possible because that's an
Get to it
additional
as soon as
protection.
possible.
That's what I just
That's
said
what
in
we're
my
trying to
closing.
tell people.
Yeah,
Get to it.
as soon as
Yeah.
possible. Mhm.
And of course, the tax exemption is a big reason to do it, right? If you're single, you get 25,000. If you're married, you get 50,000. So that's even more so for the reason to do it. So it's not just about the protection that you get from creditors, but you want to save money on your taxes because those go high.
Mhm.
Now, I have a question because, and this is probably directed back to, this might be a Steve and Laurore question. So I have somebody that is, they do not live here, but, well, they don't live specifically in that specific state that they want to live. What their question was is, while they are migrating from, I guess, one state or one country to the next, if they send their spouse to live in the property, can they claim homestead exemption if the spouse is living in the property and they are still living in another state, like they're still in transition?
So the famous answer, I guess maybe I'll let Steve answer, but it depends, right? I know people hate when I say that, but that's the lawyer answer. But it truly does, right? Because homestead says you do not have to continuously live in your property for it to qualify. For example, a snowbird, right? Where they come down to Florida for a part of the year, but they stay somewhere else. They can still qualify for homestead because this is Florida. You only have one home in Florida that you're saying this is my primary residence, but half the year you may reside somewhere else because of the weather. That's still fine. Now, if they are technically claiming their primary residence as tenancy, for example, they're saying that is my primary residence, everything goes there, mail and everything else, then technically the Florida home wouldn't be counted as their homestead. So, I mean, there is different laws and case law that goes into it because fortunately and unfortunately, because of homestead, we get a lot of people that try to hide from creditors and get a property here and say that's my homestead so they can have that protection. So you can challenge it, right? The lawmakers can challenge it to say, is that truly your homestead? Did you have the intent for this to be your primary residence? So in this case, if the wife is staying there, then that is the intent that, yes, I want to make this my primary residence. So it will qualify for homestead because I'm living here, I'm getting mail here, I vote here, right? All the different factors that says I intended to make this my primary residence and I'm actually doing so.
Okay, well, that's really good news. That can help a lot of people. That can help a lot of people.
Yeah.
I get that question more often than not because you have people that are in that maybe last year of retirement, but they don't want to miss a good deal on a house or something. And so they're opting to move their family into the home until, say, the husband or the wife finishes out that last year. So they just want them to go ahead and establish residency, get everything up and going, all of the things, and then they wrap up things, at home.
Yeah. And that's allowed
Okay.
because that is your intent is there and you're doing all these steps to make it your primary residence. So then you can go ahead and apply for homestead.
So then
Okay.
you have to have homestead in one specific place, not both places. Say they live in another country and well, not country, but another state, and they have homestead in that state, they can't have homestead in the other state as well.
Because you're
Or
just
can they
claiming
have
primary,
homestead?
yeah.
Repeat, please.
You're claiming primary. So primary is the house that you claim
You
is
currently live in.
live.
That's not okay. So it has to be one or the other.
Mm-hmm.
Yeah.
Ronise, I have a question since we were talking about this the other day. Do they have homestead exemption in like St. Thomas or St. Croix?
Yes.
Okay. All right. And do you know what the exemption amount is?
To be honest, no.
Okay,
I don't
but that's
remember.
okay because
Yeah.
that was one of the questions that the guy that I spoke to had because he does want to send, his family beforehand.
Okay. Yeah. Yeah. I
Yeah.
don't remember. I don't.
Okay.
'Cause I don't get it. So anymore.
Yeah, that's right. You
Yeah,
don't get
yeah.
it, but you might want to get it. You might want to know for other purposes that we talked about.
Yes. Yes. Absolutely. I'm already working on that, to be quite
Good,
honest.
good, good. Okay, I know that you get a lot of questions in reference to maybe should I should I have a trust? Maybe if it should be as of recent, I was told that we probably, since we do have business succession plans and everything in place, maybe it just would be a ladybird deed that would be most beneficial to us. In what instances should somebody either consider will, trust, ladybird deed, those sort of things?
Yeah, so it depends on the situation. No, and it's
I feel like that's a lawyer. That's a lawyer's.
I think they told y'all
yeah,
this is a book
like,
that you all get in law school, and
exactly.
it says
Exactly. It depends.
It's true though, because it does depend on the situation of the person because it won't be an answer for everything, right? So, for example, If I have a old married couple, right, they're older, their kids are older, they have no conditions on how their kids should inherit, and they're limited in funds. A Lady Bird deed is more straightforward, right? Because the kids are adults, they can leave the kids as a remainder interest that upon their passing, the kids get the property without any restrictions. Now, if I have a couple that has younger children and they're trying to make sure that their home is protected, a trust makes more sense for them because the children, they're under 18, so they can't get to be on the property because they're minors, they're not, adults yet. And they probably want to have some restrictions that'll have someone as a trustee oversee how that trust asset is protected and also, conditions for that.
Okay.
So it really depends on the client's situation, right? In trust law, it's mostly for people that are trying to have a condition attached to an asset. Like, I want to give you this property or this money, but I'm attaching conditions to it.
Have you seen people do like crazy conditions?
Oh, yes, all the time. And I have to remind people, right? The law allows you to be creative, but you have to really back and it has to be legal. I can't put conditions on there that is against public policy or that is completely illegal. And even some that are not illegal per se, it's
actually legal stuff.
You'll be surprised. It's like, no, sir, I cannot add that in the trust. That is not something that's going to be enforceable.
I have heard where there are people that, they have trusts and everything in place, but they're also wanting to designate like who their child would marry or
that's what I was about to say.
So that's against public policy, right? So it's not per se illegal, but we have something in law that we say if things are against public policy, we're not going to go ahead and accept that and enforce that, right? So I've had clients, they want to specify that their children have to marry a specific religion. Again, it's against public policy. We can't enforce that. It's not per se illegal to say that as just a preference, but the law will look at public policy, what's the moral, right? And also what can we enforceably do legally. So yeah, I've seen people have crazy, that's when education comes in. And I'm like, I understand your desire. However, comma, I cannot
comma
this for you.
I've heard that in New Jersey. That's what it is. I don't want to say it out here, but there's a group of people that tend to do that when they're trusted, say, hey, you have to marry this religion or specific background in order to get. And I'm like,
so for example, when that comes to play, right, it's when it's time now to enforce that. A beneficiary is being told that they cannot get their share because they have to marry. So then now we're in court. Your whole point was to try and keep everything out of court. Now the beneficiary is suing the trust to try and say this is against public policy. Then that's how we have case law. That goes all the way up to say, okay, is this acceptable for a trustee or a grantor to force this on a beneficiary as a condition to get an asset?
Yeah.
And so now all of the work that they have done is now going kaput.
Yeah.
Because now they got to go through court. That would be like someone coming to Buffy and I and saying, I want to buy a house in a neighborhood that is predominantly XYZ.
Which we get.
And cannot do. So let's put it out there, people. We cannot do that.
We cannot do that. Don't ask us about a lot of don't ask us about demographics. No. I don't want to talk about that.
Yeah, we cannot.
But people will always try to push to see how far they can get. We either within the realms of the law or outside of the realms of the law. So it's it's our job as professionals to kind of reel them back in and say, you actually can't do that. But yeah, so I would say trust is really for those people who want to be intentional, but also have conditions. Whereas if you want things straightforward, especially with the Lady Bird deed, which is not available in every state. So that's one thing that is good about Florida, allows you to add a beneficiary to your home. So you can say, okay, I have adult children. While I'm alive, the house is still mine. I can still sell it. I can still take out a loan against it. But I'm saying upon my passing, these people will get the property free and clear without having to go through probate, right? It's the most easiest, straightforward process. Literally, somebody passes away. You had the Lady Bird deed already recorded to the clerk. You submit the death certificate, title transfers. Like it is the smoothest process possible when it comes to a home transfer.
So with a Lady Bird, because I know there were probably people thinking out here, can I put it in a minor child?
No.
Okay.
Because the idea is that, right, when we do estate planning, we have to assume that if something was to happen to you today, can that person inherit right now? So to answer that question, if something was to happen to you today, can a minor inherit that property? No, because they're minors, right? So then Lady Birthday is reserved for people that are able to get it right away. So that's why we say, if you have adult children and you have no conditions for the home, then yes. But to that same extent, even if you do have adult children, but let's say you want to make sure that that property stays in the family. It's a family home. We've had those for Eatonville, for example, right? Those families are families that have been generations. Eatonville has a great history. That's like the first, established town, Black history, right? So for those people, they want to say, okay, I want the home to stay within the family. Even though my children may be adult, the best way for me to enforce that is putting in a trust, because then I can attach those conditions that has to be honored. Whereas the Lady Bird deed, you can't attach conditions to it. You get it? No conditions attached right away.
Okay.
Fun
So
fact.
really, if you're going
Fun
to choose a trust, it should be because you're doing conditions.
It should be, because that's when it makes sense. Because, I like to tell my clients, right, I'm not a salesperson. I'm not going to give you a trust if it doesn't make sense for you. I know with social media, everyone wants a trust, and it's like, it sounds good, but it's like, let's sit down. Let's talk about your estate. Does it make sense for you? Absolutely not. So why waste the money, the cost, and to have the trust and it's never been funded? Funded meaning, does it own anything?
I'm
Are we putting
so
anything
happy
in the
that you
trust?
said that. I am very happy that you said that, because everybody now believes that they do need a trust, and sometimes it's simply not warranted. It's just not warranted.
So many times it's not warranted, because what are we putting in the trust? That's a question I like to ask the client, right? Or the prospective client. What are we putting in the trust? What asset are we putting in? If there is no home, there's no life insurance, what can we put in the trust?
Mm-hmm.
And I guess sometimes we can say, oh, well, I'm pre-planning for the future, and that's fine. But a lot of times when people still end up in probate, because they had this drafted document, but they never funded and put anything in it. So it was just basically useless. Right now we're in probate because the trust didn't own anything. If you're giving all these conditions, well, you can't have the money till you're 25. You can't have this till you're 50. But the trust has no assets. What is it? What is the conditions for?
You're not distributing anything. You're distributing
air, hopes and dreams, and that's about
Hopes and dreams. Till you're 25. Here's my hope.
This was funny. The other day, as I was leaving out of here, and this guy, because we have an attorney's office in the front here, and this guy, he's coming like with some force, like he's coming to our door, and he's like, oh, residential matchmakers, and he's not even getting the residential part. Everybody always just catches matchmakers, right? Who are you matching me up with? And I'm like, nobody. Actually, I'm going home. But he was looking for the attorney in front because he wanted to share this whole story and vent to me about him going to the bank to get into his father's safe deposit box. And the bank stopped him, because he had nothing in writing, and his father did not put him any kind of like paid on death or anything at the bank to get into this safe deposit box. And he was believing that there was a substantial amount of money in this box. And I told him, I said, unfortunately, I'm not the attorney. You need to, and he was asking me about the guy in the front and everything. I don't know, do your research. I'm not saying anything.
He was trying to get you to match him with an attorney now, too.
Yeah.
Listen, I'm like, I'm trying to stay in my lane here.
Match you with attorneys. That should be your side gig.
I'm trying to stay in my lane. He wouldn't let me. I'm like, I'm just
but that's a good point to bring, though.
Those are the classic things that we run into as well, with people, of course, all the time thinking, and this is something that we always say too, as good as you think family is when you're alive, when someone is alive, it will not be the same in death.
Mm-hmm.
It will not
guaranteed
in death. And so just like he was just as, he's upset about this one aspect of it. I guess my question, this whole roundabout thing, it would have been a simple task for his father maybe to have just gone to the bank and put him as a paid on death.
Mm-hmm.
What are some of maybe like simple things if somebody is saying, I can't afford a will, I can't afford this, that and the other? What are some of the simple things they can put in place in order to get around some of these things?
And it's free.com. You go online and you add a beneficiary. It takes less than 5 minutes, right? As long as it's an adult beneficiary, right? Because if they're children, then we run into the issue of still having to go to court for guardianship. So just a quick kind of like law thing, right? If a child inherits $15,000 or more, right? So 15K or more in inheritance, they have to go to the court to get guardianship over the money, right? So because of that, we try not to add children as beneficiaries on account. But if you have adult children, you can add them as beneficiaries, and it's completely free. And upon your passing, they go to the bank, present the death certificate and their ID, and they transfer the funds to them, no problem, right? But to a point with the box, a lot of times we have where clients did their estate planning. They did what they were supposed to do, but they put the documents in the safe deposit box, and they added no one to that safe deposit box. So guess what? You still have to end up going to court to get an order to open that safe deposit box. So I tell clients all the time, right? You can't do what you're doing, right? It's good for it to, the intention is there to be safe, but that's not the best place to put it. Because if you put it there, there's no one else that can have access to that box. And now you have passed away, there are no documents. We still end up in court asking the court for an order to open up the safe deposit box.
Oh my gosh. Okay. If you didn't hear, what did she just say now, Ronise?
I'm sorry?
What did she
I
just
heard her. She
No,
said
I'm just
that do not put your document inside your safety deposit box.
Is that where yours is, Ronis? Because
no,
Yeah.
I'm just saying, just so that we can get this across to people, because sometimes people in their mind, they're thinking
They don't
You're doing the
think
right
about
thing.
it.
it's safe. It's a safe deposit box, but they're not thinking of the
Access.
other part. I need to add somebody to my account so that they can get in the safe deposit box.
Yep, because now all the work you've done, you created this trust, you have all the documents, but it's in a box. How do we enforce a document that we don't have? Right? And
Exactly.
you need the physical copy, right? So for power of attorneys, healthcare directive, those things, a copy is sufficient. But for a will and a trust, the court's gonna need the original copy. So, it's okay to put it at home in a safe, in a fireproof safe. That's perfectly fine. And giving someone the code to that. I like to tell the story to my clients where it wasn't my client, it was a college client.
It's okay.
It was a college client.
We
They were
say
trying
it's very
almost shut
impromptu, right? Anything can happen on Home Buying Agency. It's okay.
I did not mean to do that.
It's okay. It's okay. But no, another easy way to maybe even safeguard your home is when you're closing, consider joint tenants with rights of survivorship.
Yes. And that is major, because if we don't do survivorship, that's in tenants in common. And what does that look like? Right? So let's say, Buffy and I were together and we're happy, but then we break up. It's tenants in common, right? I pass away, and years later I had, children, and Buffy now owns that property with my children, with my heirs, tenants in common. Tenants in common mean that it flows down through your descendants and your heirs, right? Whereas
and
if it was
a busy bee, and she has 10 kids.
So now it's Buffy and 10 kids trying to split that property, right? Whereas if we did a right of survivorship, it literally means the last one standing. I survived, so I get to keep it. So it's the best approach. But granted, sometimes some people do want to have it that way. They want to say, no, I want my heirs to have it. But how do we still avoid probate? That's when, strategic comes in. How can I still have tenants in common, but I still can go ahead and give my interest away using Lady Bird deed? Then I can still go ahead and avoid probate, right? So a lot of people would think, well, if I already have two people in the property, that I can't really do a Lady Bird deed. That's incorrect. You can still do a Lady Bird deed for your interest, your half interest, to say it goes to this specific people, or without having to go to probate.
I didn't know that.
Probate is where it gets crazy and ugly. But yes, that's a strategy we can use as well, to say, okay, rather than leaving it to my 10 children or to whatever else, maybe I can, specify one person that upon my passing step into my shoes. Now Buffy owns it with just one other person rather than 10 other heirs, because if we went through probate court, it's going to be your heirs rather than who you've decided yourself.
That's a really, really good point. That would solve a lot of problems.
It would.
Right there,
because you then can give away your share, right? So I'm giving away my 50% interest in that property to who I want, and more. So sometimes, again, there is a reason why people want to keep their share to the family, whether it's because they put part of the money into the property, or they say, I don't want you to just take it and, be a survivorship. I want to make sure that my family gets a part. That's perfectly fine, but making sure you have some kind of tool in place to avoid probate. Because that's when it gets messy, is when we have to go to probate and you didn't have a will, you didn't have any documents. Now we have the day cousins and all of them on that deed.
Can you do me a
Well,
favor, Laura? Can you explain for the audience, like what exactly is probate? Because I know people know what the intention of probate, but we keep saying
Mhm.
probate's nasty, probate's this and this and that. Just give a description of what happens in probate. How bad does
Yeah.
it?
So probate is the process of the court determining who gets what, right? Your assets.
Mhm.
Anytime that someone passes away and they had no beneficiary designation or anything like that, we end up in probate court. Now the court has to decide for you who gets what. Now, if you had a will or a trust, you decided who gets what. Now, if you're at the mercy of the court, based on its own rules, said, okay, who's supposed to be your heirs, aka your descendants, to get whatever you want. So the probate process is you go in front of the judge, right? And there you have certain forms and certain steps you have to go ahead and fill out for them to determine, okay, who's going to get the assets and what percentage and everything else. So that process itself is a lengthy process through the court. And it's really messy in a way that it's not straightforward, especially if you don't have a will, right? And that's when the argument comes in to say, okay, a lot of times what we see is because families sometimes they feel entitled. Let's say one person was the one staying at the house. I paid the taxes. I'm the one taking care of the property. You did nothing. But by technicality, because you are this person's child, you get to inherit. Is that fair? Morally, no. But legally, yes. I like to tell my clients, the law could care less about your morals and who's right or wrong,
Exactly.
in lack of better words, right? Because if you didn't have a will to say, okay, these are my intent, my clear intent of what I want, you're at the mercy of the court. And the court's going to say, well, if that is in fact your heirs, they are entitled. So that's where the argument comes in with probate, because now we have this friction of, okay, do I get to deserve more of the asset because I did more? And unfortunately,
Mm.
that's not how it works.
I have gotten families, and this has happened on more than one occasion, where a property or a child was left to stay in a family and they assume the real estate tax. They start paying the real estate taxes. And they've been doing this for years, 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 years. And they feel like the house should go to them.
Unless mom had a will or a trust or a lady bird deed, that's his who's that the house goes to. It goes by default by that mom descendant. So if she had 3 children, then it goes equally to all three. If you had
Yeah.
two or five, so it goes by that. So that's why it's important to do, even if it's a will, even though yes, we still end up in probate, but you are telling the court what you want to happen, rather than the court saying, well, you have 5 children and by default they all get it. And to address a point that I think a lot of people don't realize, you can't disinherit a child. There is no law that says that you have to leave something for your children. So in other countries, it's different, right? But good old America, you can disinherit a child anyway, any way you want to. So if you have no relationship with that child or you do not want them, and sometimes it's not even about the lack of providing for them. I have families who one of their child is more well off than the others. So they intentionally say, okay, well, I don't want to have to leave anything to them because they're fine, but I have other children that may need it more, right? Mm-hmm. So in their will, they specifically said these are for these children. So you can't disinherit a child for whatever reason, but making sure it is written in a formality of a will so that it does not fall to the default of everyone gets equal share, if that's not what your wishes are.
I guess that's why you have those children, well, especially in like some movies that I've seen. They have these children that sitting up there and with their legs crossed, thinking that they're going to get all of this money, and kaboom, kablowy, it goes to the one that nobody had any suspicion about getting.
Mm-hmm. And it's like it goes to whoever you want. Sometimes it doesn't even go to your children. Sometimes I have clients who completely disinherit all of their children and they left it to a foundation.
Oh,
that
I know
that'll be a meeting.
I know a family that did similar to what Buffy was talking about with paying the taxes, like just constantly started to pay the tax. I think it was a grandchild or something was paying the tax. The person wasn't dead yet because they knew they were paying the taxes. Like as the person was sick and like feeble and they were in the hospital, they tried to go there with legal paperwork to have them sign it over. And it was like, no, that can't happen.
That's undue influence
in the right
too.
sound and mind to do that. So we can't do this either. So now the person is super upset because the person has died, and the other sibling, the children of the individual is like, yeah, thanks for paying it, but not you.
Thank you. I appreciate
And that is
the
the conversation that always happens at the end. Thank you for paying it.
You didn't have to.
But
Now, I mean, granted, right? So not to get too deep into the law, but they can potentially down the line make us proof of claim, right? So if the person passes away, they can say, okay, they were a creditor of the estate, they've made these claims and everything else. And if it's valid, depending on what tier it falls to, they may be able to get some of that reimbursed. But again, that's just like more so in the probate and everything else. But regardless, it's like you can't assume because you're doing something that it automatically entitles you to get anyone's property or the case may be. And to Rhonda's point, right, when you're executing your documents, you have to be of sound mind, which is important for clients to understand, like, especially in your field, as you are doing you bought your home now, what if something happens to you? If you do not have a power of attorney in place that says who is your agent prior to you not having that sound mind, that person can make decisions for you.
Right.
Right. So when we're thinking about, what happens after death, but we have to think about what happens when life happens. What if you're in the doctor's office, like, in the not doctor's office, in the hospital, and you have to make a decision, right? Who are you going to name as your agent to make that decision for you? Because you have to be of sound mind to be able to sign some documents. If you're not there, I, as an attorney, would definitely not be that person that brings that power of attorney to you in a hospital room. That's undue influence, right? Like, so you have to
Sometimes
make
these
sure.
are, like very hard conversations, especially for maybe even not even just older individuals or more mature individuals. It's a hard conversation for younger people as well, because they don't know where life is going to take them. But when you get, more mature, right, you're trying to figure out things that you weren't really wanting to figure out. You're just going about in your, your kind of daily life. So having an attorney or somebody that is, able to ask certain questions, and I'm suspecting you've done this 1,000 times over, where you have maybe couples or more mature couples coming in and they don't really know where to start, or maybe how to divide up anything. What are some of the initial questions you might even ask them?
Yeah, I mean, I think overall it's like, what are their true intent, right? So what is it that you want? What is it that you want your estate to look like? And to talk about your assets and who's going to get what. But also when we're talking about estate planning, talking about the before death part, asking that, question about willing and able. That's a keyword I always use for clients, because a lot of times we may assume that the people in our circle is going to be okay to take in that position, to be a trustee, to be a power of attorney. But are they willing and able to take on that responsibility? Especially when it comes to your living will. This is the more emotional responsibility. Anyone can handle your finances and your legal, but now you're saying this person, I'm asking them to pull the plug on me because that's my decision that I do not want to be kept alive by life support. Have you had a conversation with that
friends
person?
That they have a major issue with this with their parents.
Right? So it's asking that question, are they willing and able? Because you don't want surprises. And that's a question I ask my clients. Have you talked to them? You don't have to talk in details about your circle, about your estate and what you have. But have you had a conversation to say, hey, if I'm in a situation, would you be willing and able to step in this capacity? And this is what it involves. That I don't want to be kept alive by life support. And I'm going to put you as a person to decide that. Are you okay with that? Are you able and willing? Right? For me, for example, I'm the attorney in my family, but I absolutely not cannot do that for my mother. If it's for me, she'll stay on that forever and ever. Amen. Absolutely not. I'm not pulling the plug, right? So it's looking at my siblings among us, who is the more emotionally responsible person to do that job. And that's another question I'll always tell clients as well. You do not have to pick the same person in every capacity. Maybe one person is better at finances. Maybe this person is more emotionally responsible. Let's give them their roles accordingly and not feel like you have to put one person at every capacity in your estate planning.
I like that. I like that. I definitely, I like that a lot.
Someone posted a question, so I'm going to post it on the screen.
Okay.
So it shows how best to control how you want your assets to be distributed and handled from your grave.
From your grave. That's a trust. I like to call it like speaking from the grave, right? Or even the will in a sense, but the will does not give you the ability to put conditions. The will is more a distribution method. You tell the court who gets what, and it just honors it and makes sure it goes to whoever. The trust is how you control beyond the grave, right? That 10 years from now, you're able to say, okay, my grandchildren, my great-great-grandchildren can benefit from this, and you live a legacy. That is the best one. That's the best way to kind of continue on and really speak from the grave. A will, you're still speaking from the grave, but it's in whispers because they just get it right away. Whereas,
like how we can be talking about death and still be laughing.
So you have to have fun with it. Yeah. But whereas a trust is like you're loud and like this is what I want, and it continues on beyond.
But like you said, like you said, for a trust, it has to be something that is fed. At some point, you can't dictate something that doesn't have a foundation.
Ownership. Yeah, I've had so many clients that they've done their trust, and I ask, okay, is your property in your trust? No. And real estate, right? That is your biggest asset for most people. If you did the trust, but you didn't do the deed, the title change to put the property in the trust, even if your trust says you cannot sell that house, the trust can only control what it owns. So if it doesn't own that property via a deed, right, transfer, then it cannot control it.
Why would someone not do a trust and do all that hard work and pay and not follow through with the
You'll be surprised. You'll be surprised. At our office, we make sure that part is done.
It depends, Steve.
Yeah, it depends. Yeah, it really depends. But at our office, we make sure that part is done for you because we don't I don't want to say we don't trust the client, but we rather make sure that when you're finished with us, that main thing is done. So our process is we do the trust. We also do the deed to transfer the trust right away to your property. Whether it's using a ladybird deed or a quitclaim deed to put the trust as the owner, we do that for you because life happens. You say you're going to do it, you put it in your to-do list, you never get to it.
And then it doesn't get done.
Right? And your intentions are good and you're trying to get it done, but it never gets done. So for us at our office, we will not do a trust unless we put the property right away. Either using a ladybird deed or a quitclaim deed, we're putting it in that trust. Now, other things, right? That's for you to do. Like as far as life insurance, investment account, financial accounts, you have to go on that initiative to go ahead and put it into the trust. But if you work with our firm, guess what? We're calling you every 2 weeks in until it's done. Because I'm not going to have your family come to me, well, you drafted the trust, you didn't tell them properly. Absolutely not. Absolutely not. We make sure our clients' trusts are funded.
And I believe you answered this one before, but I'm going to share it again so that we can answer. So can you see the question? No, you cannot.
I can.
It says, should your trust or will be filed somewhere where it can be executed in case of your executor happens to lose a copy or lose the copies?
So Florida does not allow wills for safekeeping. Other states, they allow you to bring in the will and kind of safekeep it in the county until something happens. In Florida, the only time the county, the clerk receives a will is when somebody has passed away. So that's a no, unfortunately. Your trust, you didn't want to record that anyways because the intent of a trust is that it's private. A will is public. The minute that you record the will with the clerk of courts, anyone that have access can go online and see the details of the will, right? They can see, who you left to, whatever. But the whole purpose of a trust is that it stays outside of the court. So you wouldn't record that anyways, but Florida particularly does not have a wills for safekeeping law that allows you to put a will in their database for just in case something happens. So that's why a lot of times, even if you keep the original, make a copy so that if it is lost, we can have an affidavit. We can go ahead and try to show, okay, there is something done. We don't have the original, but we have a copy. We have witnesses affidavits that can show, yes, I watched this person do their will. We can bring in the attorney, but it has to be signed, right? And it has to have at least a copy of it. But the default rule is that we need the original will in the trust.
Okay. I think that he was asking more so not necessarily filed in public, but just filed somewhere. But I also think it's important to not filed in a public thing, but I guess just filed away.
Yeah, not at least it's you to.
That's not in the safety deposit box.
Yeah, not in the safety deposit box, right?
Safety deposit
not
box
in the safety deposit box.
Nobody has a POD on. Yeah,
exactly. But yeah, there's no like a place where you can go ahead and put your documents for safekeeping per se that will kind of capture, because even in the other states, right, the wills for safekeeping, it's not part of the public record yet until you pass away, and they take it and they put it in their records and everything else to keep until you pass away. But Florida does not allow that. So really it's up to you to make sure, okay, where among my house or wherever can I put my, documents that is safe and that someone has a code to.
Yeah. Now, I know sometimes people find it hard. These are kind of hard conversations, to have maybe with your family, because, really, who wants to talk about death, right? But it is an inevitable thing. It is going to happen, right? Yeah. So having the uncomfortable conversation now, it just opens up so much more.
Yeah.
I know I've, personally had these conversations with my mom. We're, trying to figure things out. And, me and my brother talk about it. Me and my husband, we talk about it. But it is like you were saying, we have to have these conversations with the people that we want in these documents before we just go putting them in these documents, because they could.
We don't want surprises.
Yeah, because like I said, I have friends that are like, that they wouldn't do certain things, and that is their parents' wish. I want to be cremated. I don't want anybody to not cremate me.
Yeah. So it's, who among your circle is gonna honor that wish, right? To say, okay, they're comfortable with that responsibility, because we don't want, especially if it's a case of, end of life, that you do not want to be kept alive by life support, and you name your daughter as a person to pull the plug, and it's that time, but you didn't tell her, and now it's like, hey, by the way, your mom left you in charge. Imagine that burden, right? That I did not want this burden. We never talked about this, but all of a sudden,
spring it on them. Yeah.
Yeah. So you don't want that's not how you want that decision to be made under, undue influence, really. That's really undue influence. Like, you're grieving, but hey, go ahead and pull the plug on mommy because she named you and she didn't tell you. So you definitely want to have that conversation, and seriously willing and able, right? Do you have the willingness to go ahead and do so? And would you be able to do it?
True.
Right.
I'm like you, Laurore. I don't think I could pull it on my mom either. So yeah.
That's why I'm not the person.
I'll be at emotional wreck.
I know my parents
multiple children. Pick another one. Find another one to do it.
Oh yeah, my mom has 7. Somebody else could do it.
Somebody can do it.
My niece is the family that has like 10.
Somebody has to do it.
Yeah.
Find somebody else, not me.
I'm just one of 2, so I know.
They probably know. Don't choose Renice either.
Oh, Steve is gonna be him.
Yeah, it's gonna be me, because my sister ain't gonna do it. She's not. No, she ain't.
It would just but those are the kind of conversations that you guys would need to have. Uncomfortable, but need to have, right?
It doesn't have to be like a formal conversation either. Like, mom and dad, let's have it sit down, right? It doesn't have to be formal.
Exactly.
It could be just in conversation to just bring it up and say, hey, have you ever thought about that? What would be your, decision? Because no one wants to talk about death. I think, even though we know it's
nobody, especially around Thanksgiving table, Lord.
Right.
Let's open up a potatoes. So what do you think about how do you want to die? How do you want to be buried?
Okay, pass me the turkey leg while you're at it. Tell me what's your wish are.
I think that's gonna have to happen, though.
That's the time you get together, right?
That's the only time we get.
That is like the most prominent time to have these conversations, because you are together. You are in one space.
And believe it or not, that's after that time is when we get most of our clientele, because after the holidays, a lot of times, right, we don't see our parents sometimes as often, but during the holidays, we can see, okay, they're starting to slow down a little bit, or they're forgetting things a little bit. Then it's like, okay, now is the time to have that conversation. So a lot of times, January and February are busy for us, because after the holidays, they've gone with the family and being able to sit with the family and see how mom is a little bit slower at things. Okay, it's time for us to have that conversation and get things done before it's too late.
Oh, that's interesting. Yeah, go ahead.
So let me, I'm going to post it, but I'm going to read it first so I don't have to squint. It says, when someone passes away, what is the timeline to present a will or trust before assets can be divided up?
Well, it's kind of a 2-part question. You have 10 days legally when somebody passes away to submit the will to the clerk. Now, does it typically happen in 10 days? No, because people are grieving. But by law, you have 10 days if you have a will to go ahead and submit it to the clerk of courts. If there's a trust, you have to submit what we call a notice of trust. Essentially tells the court, hey, we have a trust, we're going to handle it, right? Because that's the whole point of a trust, is that it's private and it's outside of the court. We found the court overseeing it. But the time frame...
Is it the same 10 days?
Yes. But again, so my legal hat, yes, 10 days. But life happens. Right. But
Laurore, are you going to do it in 10 days?
Me? If my mother passed away right now,
You're like,
the last
give me
thing I'm
20
thinking
days.
about is to go down to the clerk office to deposit her will. Like, that's not my first, thing of mine.
Yeah.
But as far as the process itself, right, a probate can take from the smallest, most simplest probate, right, from 6 months to 8 months, whereas a more formal probate, which is more assets involved, can take years. I have been in this probate for this client for the past 2 years.
Oh, my Lord.
And especially if people cannot agree on things, when you have blended families, where, for example, this should be like story of why you should get your estate planning done, right? Where you have children not in common and the spouse died. Now you have left the spouse that is not the mother of those children and your children. How do you think that plays out well in probate court?
Not well.
We can't even decide
not
on
well
who gets
in
the
court,
couch.
not well in life.
We can't even decide on who gets the couch because we're fighting, right?
The couch.
So
Oh,
that's a litigation of going back and forth and everything else, and it drags on. And at the end of the day, it's like I tell clients, right? Because you didn't take the time to do what you're supposed to do, your family's suffering, and they're spending so much money in attorney fees when that money could have went to them to, whatever that they need to do.
And then that bleeds over to then us, Rodnice, right? Because when they go to sell that asset, say Laurore has given, done all of what she does and they grant homestead, and now we're able to move forward with the sale. Now you've eaten up so much of the equity in their house in attorney's fees. The attorney either is getting paid while this is going on, or they're waiting for this house to sell so they can get paid outright. And what is left now? Because there was no planning, there was no conversation, there was no pass me the turkey and let's talk about this thing when we could. And now everything that your mom or dad or whomever has worked so hard for is now depleted with an argument, because that's all it is. It's
and going back to your main point, Buffy, when you said, I think earlier too, like you see people's true color when grief happens. Grief, I don't care how, we get along fine. Grief and money shows people's true color. Yep. I don't care if it's $1 or $1 million. Sometimes it's not even about the money. Sometimes it's about the grief. It's about the principle. And sometimes it is about the money, because now you're dealing with the grief. You don't even have time to grieve because you still have to do this legal part. So you're dealing with the legal part, the stress of it all. And then you're trying to go ahead and still deal with grieving and everything else. So clients say, we get along. Okay. I've seen this too many times of how well we get along. Okay.
We'll see.
We'll see.
That's nice.
That's nice. And I think Buffy too, I wanted to mention too, the tenants in common part, how that can become crazy. And I think Buffy working on a case together, right? As far as petitioning, right? So what it looks like now, it's like, okay, we have all these heirs, Data's kids and them, all of them in this property. And we have to force sell that property, go through the court process. And we've been at that case for about a year now, Buffy, I believe, right?
Yep.
Trying to get things done to where the court's going to agree to force sell that property. All it took was a will to say who gets what and how things are divided. And it could have been avoided, all of that.
And then all it takes is one person to say, no, I don't want to do it.
Yeah. So, moral of the story, get it done. And again, sometimes it's not about getting a trust. I think clients feel like they have to have a trust, right? There are so many ways for you to avoid probate without it being a trust, because a trust is costly. If you're getting a trust online, 99.9% of the time it's probably going to be invalid, but hey, have at it. But
Rocket Law is not good.
Try your luck. And I tell people, like, why would you try something that when it's time to use it, you're not here to explain what your intentions are.
That's true.
That is the biggest risk of life. Anything else, right? Maybe, but this is something that's going to say, okay, this is what my wishes are. And when you don't know how enforceable it is until it's time to use it.
So,
and when it's time to use it, you're not here.
So with you saying that, what is, and I know it depends. Like I said, I'm gonna get you a sign that says it depends. What's the cost for a trust? Or what's the cost for a ladybird? Like, what's the transaction? What's the basic, you'll say? And obviously, there's add-ons and everything.
Yeah. So our ladybird is straightforward. It's $750. You pay $750. We do ladybird deed. We record it for you. Everything is included, right? A trust starts at $3,500. Okay. That's the starting base, right? So if you're looking at, say, I need something to avoid probate, what is the most cost effective, straightforward? A Lady Bird deed. But if I need a trust that is going to talk more to what I need, then you look at my 3,500, right? Again, as you mentioned, it's going to depend on are we transferring one house or 5 properties?
Yeah.
Is it that we have to do more detail on how we want to structure the trust that's going to add on? But for people that think, oh, it's so expensive, you're paying $750 for a Lady Bird deed that's going to protect your home. You know how much we charge for a summary probate?
Mm-hmm. Yeah.
$4,000 for a probate.
Yeah.
For a formal, you're looking about $6,000 and up just in attorney fees and then the probate costs, right? The filing fee for a probate for a formal, for example, is $450. So just to file the
couple
probate,
of more hundreds and you get a Lady Bird deed.
Yeah.
Exactly. So it's like, what do you want to spend your money on in time to protect your legacy? And I tell people all the time, it's not about, what do you want to leave behind? Because do you want to leave that your family remember you that grandma left me a mess that I have to clean up and figure out everything else? Or that I took the time and to intentionally say, okay, I want my family to just be okay. And under the circumstances, things go as smooth as possible. That there is no bickering, there is no fighting, that it was just very straightforward and they could remember me, right? And grieve me properly, then be mad at me because I didn't leave anything in place for them.
There's a couple of different things that popped up in my head. But first, like for a Lady Bird deed, can more than one property go on that Lady Bird deed, or is it a property per deed?
Per deed. Because as you know, when you do a deed, right, we have to specify the legal description and the parcel ID is for that property. So now they can be Lady Bird deed on 2 Lady Bird deed for 2 different people on that same property, right? Going back to the tenants in common, right? I want my share to go to this person and this other person want their share to go to this person. So we can have 2 Lady Bird deeds for the same property, but every property is going to have their own deed.
Okay.
Does that make sense?
No, it makes perfect sense.
Okay.
And now when we were talking about the whole like safe deposit box and not keeping it in there, because this is something too that doesn't help the grief process, is when people are trying to search for things. They don't know where mama put this stuff. They don't know where daddy put this stuff. Grandma got her stuff under the mattress, in a shoebox, in a little cubby behind the closet. Nobody knows where anything is. Maybe you sold the house and you left whatever important documents somewhere hidden in there. It should be also a conversation too. Where are these
centralized
documents? So you can put your hands on passwords. You can put your hands on this living and breathing document, so that you know what to tell the family to do. This is what we need to follow, y'all. This is what we need to do.
And part of our process, we give you a binder that has like all the details, right? And the goal is for you to have all those documents, because a lot of times, like you mentioned, we know mom had a life insurance, but where? There are so many companies out there. How do we find out where it was? So if you put everything together in a binder, it's just like, okay, it's a centralized location. And part of our binder, we also include instructions for the beneficiaries, because really that's who we're going to be talking to, right? To say, if mom happens, here's the first thing to do. It details step by step, from knowing how to cancel a credit card to knowing how to go to the DMV, right? Like a guide to know that. But I think the key is making sure you have a centralized location, a safe location that you can say, this is where everything of importance is. And like you mentioned, even passwords to computers, right? Because you may be able to try to have access to something, but we don't know the password. How do we get access to it? So making sure you have a centralized location, not too safe now, right? Again, safe deposit boxes are no. I had a client, not a client of mine, but a colleague, where they were mentioning that a client, they had a safe deposit box, not a safe deposit box, a safe thing at their home, but the way to open it, and they had no backup opening, was their fingerprint. Well, sir, you're dead now. So how does that work? So how does that
work? In the world?
Right? So you're thinking, I want to be safe, like, Mission Impossible kind of safe, like, and you went a little bit overboard because it's your fingerprint.
Now we got to cut your finger off.
Right? So they had to essentially bolt it open. So again, thinking safe, but not too safe. So you put it in the safe, in the safe at home, someone that you trust to have the code, right? Someone that you trust to have the key to be able to access it. It doesn't make it harder for them.
Oh my gosh.
We have
imagine cutting somebody's finger up to open it up.
I know
she's doing the church fingers.
Yeah, 2 minutes. 2 minutes left.
I'll tell the pastor, hey, you got to carry it up. People got to go get lunch.
Well, I just wanted to thank you very much, Laurore. We do try to stay with what we say, and that is to end at 8 o'clock. But this has been an amazing conversation. I cannot thank you enough. I think that people will play this back and back and back again. We will caption some of this information, put it out on YouTube, put it on our other socials so that people will hopefully reach out to you. But if you can, tell us your contact information.
Yeah, so it's info@jplawandwealth.com, which is our email. That's the best way to reach out to us. Our phone number, which is 479909468, or our website, which is www.jplawandwealth.com, or our social media platform. We're on there as the finance attorney. So the finance attorney.
All right.
If anything you didn't learn about Laurore tonight is that she doesn't make her decisions based on making money. If you didn't realize that, because she said numerous times tonight, don't get a trust if you don't need it. And she will make more money that way, but she's trying to save you. So if anything else makes you choose her, know that that alone means that she's a woman of her. She's an ethical person. Because
that's right.
Thank you. Yes.
That's right.
So we are at 8 o'clock. And this was one of the, we have not had this much loves. So we're talking about something so morbid in a sense, but it was such a great conversation. It honestly was. It was. And we have another love right now.
Right? So everybody wants to know.
Happy Black History Month, guys.
Right?
Yes. Happy Black History Month. It is the 27th. We got one more day.
Yes.
Celebrate.
I think this year is the 100-year anniversary. So,
Yeah.
That's right. That's right. And we're all Black. So
if you didn't notice.
Goodbye, Facebook. I'm going to be signing off. You guys don't have to, but I'm going to be signing off of Facebook. Have a good night, Facebook.
Bye.